Robert, what happens now?
So the potentially big intervening event is what the Supreme Court does on the D.C. case concerning immunity. I think this verdict was one of the worst things that could happen for the people hating on Trump, because it's going to further motivate the Supreme Court to issue as broad and expansive an interpretation of immunity as possible. The three constitutionally conservative jurists, Alito, Gorsuch, Thomas, had already voiced great skepticism about what was happening here and suggesting an expansive interpretation of Article 2 power consistent to it, which, by the way, they're consistent on that in other areas. So the big questions were Kavanaugh and Roberts and Barrett. Barrett was such a wuss that she's unreliable and untrustworthy, unsurprising to some of us.
Let me pause you there just in case anybody's brand new to the channel. Supreme Court is sitting on or preparing to issue the ruling on the immunity question that was brought up in the DC case. And we covered it at length. There's going to be varying scopes of immunity that they might recognize. They might issue something of a test to determine if something was presumptively presidential or not, in which case you might have to go through some sort of an immunity test before even determining jurisdiction over the case. Or they might say, absent impeachment and conviction, there will be no prosecution ever once a president has left office, less likely. So Supreme Court is going to issue that in the coming weeks, maybe in the coming week. The question is whether or not, as a result of this, some of them might go back and revise the scope and extent of their reasons.
Exactly. Like they could come down with, one ruling would say there is no presidential immunity and affirm the D.C. courts. That would have no impact on the New York case, but I think that's highly unlikely, especially now. They're seeing the political fallout in live time. They're seeing how embarrassing this legal proceeding is. It's no longer a hypothetical. What would happen if you had a crazy prosecutor, a crazy judge, and a corrupt jury fix a case against a former president of the United States who's the leading opponent of the incumbent presidential administration? It's no longer a hypothetical as to what that looks like. We've now seen it. And to give people an example, if there is no presidential immunity, every president could not only be indicted by any prosecutor anywhere in America, but by any prosecutor anywhere in the world. And if that country had an extradition treaty with the United States, what would be the grounds to prohibit extradition? Mm-hmm. If a country in the Middle East decides that President Obama committed mass murder with his drone bombing campaign, what if they indict him? And what if it's one of the countries that has an extradition treaty with the United States? How does the United States refuse to send Obama back for the death penalty execution? A president standing in front of a death penalty squad. Same with George W. Bush. Same with William Jefferson Clinton. So, how do you avoid that? Now it's no longer hypothetical. We've seen in New York what this looks like. And so I think it puts massive pressure on the Supreme Court to issue an expansive interpretation and reject the no immunity application. Then they've got two options: limited immunity that's very fact contingent, or broad immunity. They're right now under massive pressure to give broad immunity because they can see the only way to really preclude this from reoccurring, from us being a laughingstock of the entire world, us being the country that now, needs bananas to replace stars in our American flag. And by the way, the Banana Republic comes from the U.S. CIA, the Dulles brothers, being involved with the United Fruit Company as their corporate counsel, while also being in the U.S. government and holding shares of the United Fruit Company, overthrowing governments. And because United Fruit Company was a big banana company, that's where they started referring to countries as, quote, banana republics. It's all deep state coup history. That's why it's especially applicable here to the deep state coup effort against President Trump. For those that don't know, the lead idea prosecutor behind this, who was standing behind Alvin Bragg right after they announced the guilty verdicts, is one of the top highest ranking officials in the Biden administration. He resigned his high ranking position in the Justice Department to go prosecute this case. So have no illusions. Shannon Bream may be asleep at the wheel and not know the connection between the Biden administration in this case, but anybody that can actually see or read knows the Biden administration connection to this case. So the way they could get rid of all these cases is very simple determination. One that, in my view, has been straightforward from the plain text of the Constitution and the public policy purposes served by that plain text, which is the only place in the Constitution it allows an indictment of a president of the United States is if and when he has been impeached by the House of Representatives and convicted by a 2/3 vote or more in the Senate of the United States on those specific charges. That's the only time it says you can prosecute and indict a president of the United States. So that's what they should say. Until he's impeached and convicted, you can't prosecute him, period. Otherwise, he's subject to and here's how he's subject to ongoing extortion while president.
Mm-hmm.
While president, prosecutors could come to him domestically and internationally and say, hey, if you don't give me what I want on this policy, regardless of what the American people want, then I'm going to indict you and put you in prison when you leave office. So you can't have that. But otherwise, Article 2 power, which says all executive power is vested in the president, doesn't mean anything. Same article, different variation of those same Article 2 issues applied in the other cases. So, but let's say they don't go there. If they go there, this case is vacated. Every single criminal act alleged in the indictment happened while he was president of the United States. And for the reasons you just articulated about the only legitimate theory they can have as to the timing problem they have in the case, namely that these acts are taken after the election, and that even the underlying acts he's supposedly covering up were not due until after the election, was to avoid impeachment as president of the United States, making them presidential acts. But under a broad Article 2 and impeachment clause interpretation, all that's moot. It's like, look, doesn't matter. You can't charge him with any crime for anything he did while president unless you first convict him by the Senate. That would vacate the entire New York verdict.
And the classic argument to that, and I think they raised it during the immunity argument, is that, well, if you have a corrupt Senate who refuses to convict, then you have a president that's above the law. And I'm like, if you have 66 people who are so corrupt that they refuse to convict, well, I'll take my bet on 66 corrupt people versus one corrupt DA or attorney general after the fact who single-handedly can corrupt the entire process. All right, so you have a Senate, 66 corrupt Senate, you got a problem, but I'll take I'll wager my bets on 66 people versus one Leticia James or one Alvin Bragg, because you only need one corrupt person with limitless power to do it, which is what they're going to give them. Okay, sorry.
Exactly. So the second option is for them to sort of split the baby and say that, well, a president is immune from criminal prosecution for any presidential act. But for any act taken in his purely private or personal capacity, he's not. What that would require is the court to go through an entire indictment and see which acts are personal, which acts are presidential, and strike all the ones that are presidential from the indictment. Also, when it comes to evidence, exclude any evidence of anything that's presidential. And in terms of instructing the jury, instruct the jury on the difference. Of course, none of that happened in the New York case. The New York case never applied that. And there's a little bit of an issue with Trump's lawyers not easily preserving issues for appeal. Now, I believe he still effectively raised this issue because he raised it when he first removed the case to federal court and said presidential immunity gives him grounds to go to federal court. And the federal court just summarily denied the immunity claim. So in my view, he did preserve it. However, it could have been a lot better preserved. They should have been hammering it over, and this is an argument I make with defense lawyers all the time. Don't let the judge intimidate you. Preserve. Dershowitz has been hammering Trump's lawyers for not preserving. He understands this as an appellate lawyer. That what happens is when you're right in front of the judge, you're discouraged from doing so. The judge's like, oh, you already did that. You know, why are you doing this? The judge gets annoyed, rules against you on a bunch of things. And so as a defense lawyer, you're inclined not to poke the bear over and over again. But you have to in a case like this. Case like this where, you know, the jury's rigged, prosecution's rigged, witnesses are rigged, the judge is rigged. You've got to preserve every appellate issue over and over and over. You can do it diplomatically. You can do it courteously, with courtesy, but you still got to do it. But I think he still has enough there. So, but even if they make that hybrid ruling, because this judge never even applied that at any level of the case, in my view, it's grounds to immediately go in, overturn the verdict. Judge, you've got to do this standard. We've got to restart from the beginning all over again. And because, again, people haven't looked at this, while they're saying his intent was to cover up a crime that was intended to, in turn, cover up something that happened before the presidency, all the actual acts that are alleged as crimes, the actus reus, and even the mens rea, is while he was president. And that, as you pointed out earlier, the only way you can even get to any criminal intent is to suggest the bridge being him wanting to avoid impeachment, which makes it presidential acts by definition, in my view. And so so I think either way, I think the likely Supreme Court verdict completely invalidates this verdict.
There is no chance the Supreme Court verdict is going to be anything other than, at worst, some acts are purely personal, others are purely presidential, and you need to make the distinction.
There'll be more immunity than the D.C. Court of Appeals or D.C. trial court granted. I think that's a 90-95% chance. And that means this verdict is tainted just on those grounds, and is the quickest, easiest way for the verdict to get thrown out. Now, this corrupt trial court refuses to even recognize the Supreme Court ruling. All that does is accelerate the appeal issues where he could get a stay of the sentence pending appeal because of this Supreme Court ruling. And so now that's just those issues. There's every kind of evidence issue. There's every kind of jury instruction issue. There's every kind of jury selection issue. There's a wide range of issues that are unique, and there's evidentiary issues about directed verdict and evidentiary issues about appellate record review, which are unique in New York. Those issues would only be decided by the appellate division in the New York Court of Appeals because they're New York state law specific. The long and short of it is they were denied cross-examination of certain witnesses in violation of New York rules. They were denied the opportunity to present witnesses on their own behalf in violation of New York rules.
The expert denial, I don't even understand it, especially since the judge referenced FEC law in his jury instructions, which makes absolutely no sense. So there's that. Refusing the admissibility of evidence, I thought, at least under civil Quebec law, was immediately appealable because it changes the outcome. Allowing prejudicial testimony that was irrelevant, i.e. Stormy Daniels, that you go on and say, okay, well, you can deal with that afterwards, but if we don't allow them to make evidence, that can't be undone. Keep going.
So, all the Stormy Daniels evidence that was let in that never should have been is itself grounds for reversal under New York rules of evidence. The exclusion of the expert witness about how campaign finance disclosure reports functionally work, that exclusion was by itself grounds to reverse the verdict under the rules of evidence under New York law. The jury instructions misstating the law were grounds to reverse the jury verdict under New York law. The precluding the defense from making certain closing arguments and allowing over objection certain prosecutorial misrepresentations of law and fact in closing arguments is itself reversible error under New York law. Aspects of the way the jury was selected, including allowing people on the jury who admitted a preconceived bias on the case and against the defendant, is a violation of New York law. So you have all of those New York law violations, but those will be specific to, and then you have the directed verdict, as I mentioned at the top of the show, that should have been granted. And in New York, uniquely, they don't have to give a certain deference to the jury. If they think that the evidence was insufficient or insubstantial to convict, they can overturn regardless. It's one of the most jury skeptical appellate standards that exist anywhere in the country. So if the New York Appellate Division is conscientious either about justice or the law, or the New York Court of Appeals is, they will, on New York law grounds, salvage their public reputation by overturning this verdict. But if they don't, that's where the robust federal constitutional issues that President Trump needs to preserve throughout this case going up, needs to highlight throughout, because the Supreme Court of the United States does not have jurisdiction over the New York state law violations that occurred in this case. They do have jurisdiction over any U.S. constitutional right that was violated in this case, and that's being overlooked by a lot of the legal commentary, because what prohibits a Kafkaesque trial in America is the due process clause of the Constitution. So that's what precludes the government from convicting you without telling you what crime it is, which is what happened throughout this case. That's what prohibits the government from hiding discovery from you or producing that discovery on the eve of trial and the court denying you a continuance. It's the due process clause of the Constitution. What prohibits illicit evidence from being presented at the trial, like the Stormy Daniels testimony, or what prohibits the court from excluding you being able to present your own witnesses, like the FEC expert, or prohibit the court from trying to intimidate counsel and witnesses, like the court did with Mr. Costello, is the due process clause of the U.S. Constitution. What prohibits instructing the jury they can find a person guilty without even agreeing what crime they committed, without even agreeing beyond a reasonable doubt, without even agreeing unanimously? All three are separate individual violations of the due process clause of the United States Constitution. And so, and what prohibits the prosecutor from the court from prohibiting the defense from fully presenting closing argument, and prohibits the government from lying about facts and law in closing argument and suborning perjury, like they did with Michael Cohen, is again the due process clause of the U.S. Constitution. So all of those New York legal errors are also U.S. constitutional errors. And as such, as long as Trump's counsel adequately preserves and protects those errors, that gives the Supreme Court of the United States jurisdiction to both suspend any sentence pending appeal or grant bail pending appeal, and gives them jurisdiction to reverse substantively and overthrow and throw out the verdict, independent of the Article 2 impeachment clause issues that are uniquely present here as well. Last but not least, there's clear First Amendment issues. This is a classic case of selective prosecution, of retaliatory prosecution. Not only did Hillary Clinton actually commit this crime in New York and was never even investigated in New York for it, least of all indicted or prosecuted for it, this particular subset of charges has never been charged in the history of New York. Nobody that's in a private business has ever been charged with a crime for how they did their internal bookkeeping meant for themselves.
Defrauded the people, Robert. It defrauded the New York people.
Exactly.
Let me say, I want to answer this one. Did Trump declare it as a campaign expense or no? He did not, as far as I understand, right?
I don't know what ultimately happened. To my knowledge, that's correct. He never declared it as a campaign
expense. And never claimed the deduction.
Their argument is that he had to declare it as a campaign expense. So the thing was, but it was a campaign expense only post-election, and it wasn't really a campaign expense. Or if all of this is a campaign expense, then Hillary Clinton clearly committed the crime at scale. And so so he has a classic selective prosecution claim, clearly. And here he is the best selective prosecution claim maybe ever brought. The prosecutor announced during his election, please vote for me and I'll find a way to indict Trump.
Well, he's got that with Letitia James as well. I think he's got that with Fani Willis as well. All three of them.
Correct. And you know what that's a natural bridge to, we get up to next, is the Supreme Court just issued a very big decision, 9-0 unanimous, about abuse of government state power in violation of First Amendment rights. And guess which state it concerned? The state of New York.